Right, hello to everyone, and welcome to our event on independent fund directors. My name is Iris Chu, director for the UCL Centre for Ethics and Law, and this event is jointly brought to you by us and the IOD Institute for Corporate Governance. Today's chair is Dr. Roger Barker, Director of Policy and Corporate Governance at the IOD, and so I shall hand over to him to make some opening remarks and to open the event.
Well, thank you very much, Iris, and hello to everyone. I'm delighted to be here today to talk about fund governance, this joint event with the IOD Centre for Corporate Governance and UCL. I want to start the discussion by referring you back to the FCA's Asset Management Market Study, the final report of which was published in June 2017, which came to a number of interesting conclusions. One was that this was a sector in which the UK was a real market leader, second only to the United States, and managing close to 7 trillion of assets. A second interesting finding was that this was a very profitable sector. Some might say a bit too profitable, with average profit margins of about 36%. A third finding, perhaps more worrying, was that there was very little obvious relationship between the charges being levied on investors and the performance of the funds that they were investing in. And if you then combine this finding with some of the reputational damage to the sector, which was associated with the collapse of the Woodford funds, you may remember Neil Woodford's flagship fund collapsed in 2019, trapping about 300,000 retail investors. There was from this, I think, a strong prima facie case for the FCA to consider if reforms to the sector were needed. We now fast forward to 2019. The FCA took a bold new step and launched a new requirement that for independent directors to oversee the functioning of mutual funds, following an example that had been in place for many decades in the United States. And specifically, these independent directors were required to undertake value for money assessments of their funds on behalf of investors. Now, the early scorecard on how good a job they're doing in this respect isn't particularly encouraging. The FCA produced an initial assessment earlier this year. They were critical of the role that independent directors were playing in this value for money process. And so I suppose the question for today is as following. How can we improve the role that independent directors are playing in fund governance? Do we need to change the selection process for these independent directors? Do they need better education or orientation, or do they need more resources available to them? Or does the regulatory framework in which they're operating need to change? And perhaps for me, the most fundamental question for us to address today is this experiment, this FCA experiment in funds governance, worth continuing with? Or is it enough to simply place our faith in the regulator to safeguard the interests of investors? I hope that all these questions are going to be answered by our distinguished and excellent panel that we have for you today. What I'm going to do is to introduce each of them, and they're going to speak for around 10 to 15 minutes, presenting their initial observations, their initial thoughts. While they're speaking, please do use the Q&A function within Zoom, because when everyone's finished speaking, we'll move to a Q&A session. And I'm really going to take the cue from you, our audience, in terms of the questions that are asked. So let me start by introducing our first speaker, and that is actually my co-host, Professor Iris Chu from UCL. Iris is Professor of Corporate Law and Financial Regulation at UCL, and also Director of the UCL Centre for Ethics and Law. She's published extensively on company law and financial regulation, and I must also mention very proudly that she's a member of the advisory board of the IOD Centre for Corporate Governance. Her latest book, you might be interested to hear, published this year, is entitled Regulating the Crypto Economy. So that sounds an absolutely fascinating book. But on the subject of investment funds and independent directors, Iris, maybe I can ask you to present your initial thoughts on that topic.
Right, thank you, Roger. Thank you for the kind introduction. I probably have my fingers in too many pies, but I hope tonight I'll be able to provide an overview of basically a paper that Roger and I have been drafting for the purposes of tonight's panel, in terms of looking at the UK regime in particular and regulatory expectations. This slide is just an introduction to the background for how mandatory independent directors for authorized fund managers came about. And as Roger mentioned, came about after the asset management market study. And the main concern was that one key aspect of investor protection is really that they're getting value for money. It's very difficult for retail investors in mutual funds to be able to really assess that properly. And if there is a monitoring mechanism from the inside of the fund, hopefully, sitting at a level that's proximate to how the fund is running, and able to make an assessment from the inside for the benefit of investors, then that would be very beneficial for investors. And so we look at how the FCA has introduced this requirement for mandatory independent directors as being one of supplementing regulatory monitoring to meet the investor protection objectives for retail investors in mutual funds. And so it is a relatively narrowing monitoring mandate for these independent directors. I mean, their task is really focused on the obligation for authorized fund managers to assess value for money. And this role is basically placed in the wider backdrop of fund governance as in terms of the regulatory framework in the UK, as is inherited largely from the EU. And this regulatory framework shows us that there are actually a lot of monitoring mechanisms in fund governance at different points of fund operations. We have the permanent compliance function that deals with the compliance obligations for the FCA's regulatory framework, the independent risk management function, the depositories, as well as independent valuers, and they are all checking and monitoring different points of particular risk to investors. And so the independent director for an authorized fund manager is really placed in this position to help with the fund manager's assessment of value for money, and is seated within the fund manager and is supposed to provide critical input and challenge, as the FCA survey now emphasizes. Now, the FCA survey in 2021 of how effective the value for money assessment is, as well as how good the independent directors are critically challenging this, has resulted in some mixed findings. So there were some good practices that were praised, but largely the FCA also commented on the practices that were short and what they wanted to see improved on. And our paper critically reflects on regulatory expectations in particular, as well as where the gaps might be in terms of where independent fund directors may see themselves as and what the FCA expects them to do. One of the key things that we thought in relation to the independent director's role on authorized fund managers is that the mandate for monitoring is actually really pretty narrow. And it is one removed from the fund, because the independent director is not seated within each fund, but rather in the fund manager and overseeing a number of funds that the fund manager is managing. However, that being the case, the narrow mandate is still investor facing in the sense that the independent director ought to have his or her focus on the issue of whether or not the value for money assessment is robust. And in this manner, we think that regulatory expectations may be better met by looking at conditions of appointment or recruitment for such independent directors. And one of the key things that we thought is relevant, which the regulator does not articulate, is whether or not independent directors should actually have high standards of financial literacy and economic abilities in order to be task focused. I mean, if their mandate is to monitor for the purposes of this task, then surely the qualities that are relevant would be those that are most relevant to the task. The emphasis on independence, however, comes from possibly borrowing from the equivalent of the US institution, which has been around for a very long time. And the quality of independence is important because independent directors of mutual funds in the US are largely relied upon to mitigate conflicts of interest. And the independence quality is a signal towards that mitigation. Although these independent directors in the US are similarly steered towards the same task, which is to secure an economic package of costs and fees for their investors. But we think in the backdrop of our fund regulation, which is already full of different forms of monitoring mechanisms for different aspects of investor protection, perhaps the FCA could do better in articulating the exact qualities and conditions that they are looking for in these independent directors. So we think recruitment based on financial literacy may actually be more important. And perhaps a specific board composition requirement, such as a value committee on the authorized fund manager, could be important, because that then shapes independent directors' task focus towards that specific job. And we also think that specific training or certification in relation to the skills that are needed to perform the robust challenge to the value for money analysis could be important. So these are perhaps conditions that regulatory policy can improve on if regulatory expectations for these independent directors are to be met. On the other hand, we think, however, that there is scope for thinking about expansion of independent directors' roles on the authorized fund manager. And this is because funds do experience new challenges and changes from the ground up. And independent directors are seated at a certain level of proximity to be able to see some of these ground up developments and possibly able to provide a monitoring role before things actually go wrong. And so would the FCA consider this? And would the FCA say that they have actually already perhaps put in a provision that approximates this particular role? I mean, there is a provision currently in the FCA handbook saying that independent directors of the authorized fund manager are acting in the best interest of the ultimate unit holders. Now, this is considerably vague. And so to what extent are we expecting them to be performing a general monitoring role? There are two areas of new challenges that we particularly see, and one is liquidity management and the other is in the regulation of sustainable investment. I mean, for liquidity management, Roger has already mentioned one of the key issues that we are looking at in terms of managing crisis at funds would be liquidity management and the fallout and the lessons from the fallout of the Woodford funds. Funds that are suboptimally managed for liquidity purposes can result in a lot of damage to investors. And so would independent directors or the authorized fund manager be in a good position for this? On the one hand, they may be able to see ground up developments. On the other hand, they may not be close enough to the micro issues such as portfolio composition and what's actually happening in the portfolios. And finally, we also think that the FCA may consider this issue to have market stability implications and may therefore adopt a different approach in relation to more prescriptive prudential regulation. So if that's the case, then the monitoring role may not be enough, basically, for such an issue. But for sustainable investment, there is some scope for thinking about independent directors' roles. This is largely because EU regulations of late have imposed new obligations for all investment funds to integrate sustainability considerations in portfolio management. And the UK is likely to develop new across-the-board disclosure obligations on the climate footprint of investment funds. And for funds that wish to market sustainably labeled products, they would have to see if EU regulations in relation to their new compliance expectations would need to be met. So there is some role for independent directors to get into the monitoring of this at a strategic level to prevent greenwashing, to boost investor confidence. But then again, we may say that some of the compliance obligations are detailed, are technical in nature, and perhaps the compliance function is better placed for this. And against the backdrop of EU regulation, which has never actually placed any reliance on the monitoring mechanism of fund directors or independent directors, it would seem that the FCA may wish to rethink how they wish to marry the role of independent directors into this mosaic of regulatory monitoring. So ultimately, we think it is a policy choice for the regulator how they want to use independent fund directors. For a narrow mandate, there could be needs for much better articulation of what conditions, what qualifications that these directors should come with. But for a broader mandate, much more regulatory support might be needed in terms of the regulatory framework to facilitate such monitoring, as well as to articulate expectations. So we think that there is a lot more development that can come in this landscape. And this concludes my overview of this area before I pass over to my fellow panelists. Thank you.
Well, thank you very much, Iris, for kicking things off there. So now I'd like to turn to our second speaker, who is Richard Frase. Richard is a partner at Deschert LLP, the UK law firm, covering all aspects of financial services law. And I should mention that in the 1990s, he was head of litigation at the forerunner of the FCA. But Richard, over to you for your perspective.
Thank you very much, Roger. If we can have the slides up. So I'm going to talk fairly briefly about, and I'm going to try and focus on observations and experience a little more than theory, specifically in the AOV context, and I've called the independent directors INEDs, which seems to be the catchy phrase at the moment. So if we could have the first slide after that, please. So one of the things that rather struck me in this is the different ways that the various jurisdictions come at this, and Iris has already touched on this. So in the States, what you have under the 1940 Investment Company Act is a situation where the fund board, and we're talking mostly about retail funds here, I think, the registered funds, is actually presented to by the advisor, and they're sitting there and they're considering whether they think the disclosures that have been made give them confidence in the advisor itself. So that's quite a strong commercial dynamic we've got there. Similarly, in the wholesale markets, and hedge funds in Cayman, wherever, you've got the manager has to cope with very sophisticated investors who will do intensive due diligence and be very interested in what's going on. So you're not just sort of doing it in your own echo chamber. You are actually engaging quite regularly with large institutional investors who will have strong views on things. Now, if we then turn to where we are with the UK retail market and AOV, we've got a system, and it may be that it's quite an innovative system, but it's all regulatory generated, and indeed it's based to some extent on theory and to some extent on the European approach, which is you issue rules to which the manager has to conform and comply, rather than actually setting up some kind of manager-investor dynamic. The slide that we should be on now is risks of self-certification approach. That's it. So, and I've called it self-certification to be a bit provocative, because that does have a flavour of, if you are doing the review of yourself, then the chances are you are going to come to a sort of favourable conclusion, which I've just called confirmation bias for convenience. I mean, it's actually slightly more than that. It's sort of, everything's sunny and look at the upside rather than the downside. So that's just a tendency that will come from that approach, which you wouldn't necessarily get in the dynamics that I've been talking about in the other two systems. That there's also, because this is quite detailed and rule-based, certainly when you get down to the type of reports that are being produced. And again, if we're talking about the larger asset managers in the UK, who are very sort of process-driven in any case, because they have to be, there is a risk of losing sight of the wood for the trees, and just getting really involved in the process and box, well, to some extent box ticking, but the detail, and losing perhaps sight of some of the holistic view of what's actually going on at the firm. I mean, I may say that the AOV reports that have come out, the disclosures, don't come across as sort of over detailed. They're actually almost under detailed, I would suspect. So, but it's what's going on under the bonnet that sort of really matters. There's also the scale of the exercise, and again, perhaps starting with the largest houses, it's a really huge exercise that they're having to undergo. We're talking about, you know, for a fund manager with, I don't know, 40, 50, whatever sub-funds, timescale of months, separate teams dealing with each of the 7 criteria, engaging an external advisor to provide peer group input, and then bringing it all together into a report and taking action on it. So it's not something which is going to be that easy for a smaller fund to do. Of course, with the smaller fund, the landscape ought to be a bit simpler, but on the other hand, they're just not going to have quite the same resources for scanning the market and other details like that. So it can be, I mean, these are some of the challenges that are going to have to be worked through in this system as it develops. If we could have the next slide, which is role of independent director. So turning now from as it were, the starting line to where the independent director fits into this. I suppose, I mean, I'm certainly a fan of the independent director and their role in the international funds and the US funds, and I think it's very helpful. The OIC UK structure is set up to be capable of having independent directors. It's just that no one's ever really appointed them. They've always just appointed the ACD. So the level of independent challenge you get from an independent board of directors is great. There is a counter view on that, which I think is entirely fair and appropriate, which is that this is complicated stuff, and certainly if you're looking at processes of the sort that are involved in AOV, an independent board may, even if it's quite competent and experienced, struggle a bit with that. Whereas if the independents, the INEDs are actually part of the ACD and are going through the process as it evolves, the ACD can actually brief them better in a best case scenario and keep them in the loop, as opposed to just having them sitting there sort of on a periodic basis, being presented to and then going away again. And one of the issues with the independent board is that are they going to be sort of passive yes men, or are they actually going to engage? I discussed this with a couple of independent directors, and because they were professional independent directors, they were really quite adamant that you know that it wasn't in their interest to do that. That was their career, that was their job, and their reputation was actually essential to them. Because of that, they couldn't afford to get involved in regulatory problems or fund problems where the board behaved ineffectively, because they wouldn't get any more work out of it. So I think one of the definite features for an independent director is a degree of professionalism in the approach, and I would suggest also experience. Although Iris touched on a number of other rather more sort of granular skills and qualities, but I think experience, and this is to some extent just a personal cut on the whole thing, by which I mean not necessarily actually having been an asset manager, but quite often it's a case of having been worked for a depository, or possibly administrator, or sometimes a legal advisor. where you have had some experience of something along the lines of due diligence on a fund and the way it actually operates in practice in terms of its business. Board dynamics, I think, really do need to be mentioned, although it's a very soft concept. But people have got to get on with each other. They've got to relate to each other in a way which brings out the best in them, and fire off each other in a way which is creative and not overly hostile, so that they're conscious that they're all bringing different qualities to what's going on. I've mentioned delegation and oversight because I think for the independent directors, and I'm thinking slightly more of the ones outside the UK structure, what I'll call the international ones. An awful lot of what they do on a purely INED board is relying on delegation and oversight of delegation. And I think the point there that one would perhaps stress is that you can't just rely on reports coming back from the asset manager. I mean, obviously that's going to be the main component of the whole thing, but you do need to speak to other people as an independent director. You do need to have direct contact with other service providers as well, such as the depository or the administrator or whatever. Last bullet on that particular slide, INEDs and the AOV. Well, I've had different reports from this. Of course, the FCA report from July says, well, some of these INEDs actually didn't really seem to know what was going on, and actually some of them even weren't in favour of the whole project. Other comments I've heard is that actually if they were right sort of INEDs and they were brought in the right sort of way and involved in the right sort of way, they were very on side and very constructive and positive. So I think there is scope for something for the INED role to go in different directions. Again, frankly, you get back to the quality of the person involved, and the quality will tend to come back to their level of experience and interpersonal skills, if that's a meaningful concept. Next slide, please. So just to sum up at this point, lost it. Yeah. So direction of travel. I think there are some sort of criticisms which I've sort of implied, which in a way are perhaps unfair if you're innovating a new concept, which might actually be quite constructive once it's had time to bed down and operate for a few years. I mean, the 15C process in the States has been around for quite a while, and it's very familiar to everyone, and people engage in it quite effectively. So this may be the results of the AOV approach in due course. The first bullet, I've suggested a question as to what is this actually aiming to achieve? Is it substituting for, and I'm using my own criteria here, the institutional investors I've been talking about, the independent fund board, or a rather more abstract perfect market, perfect competition concept. I would personally hope that we keep away from abstract, hypothetical, perfect competition models and focus more on replicating, I mean, ideally what an institutional investor or an independent fund board would be driving if there was such a thing in this situation. And it's of course, it's a bit of an ask for an ACD or an asset manager of whatever sort to fill in that role for itself, because at times it feels as if they're negotiating against themselves. But that's not impossible. Maybe that's what's where we'll get to. I put baseline against ongoing review because I think that's quite an interesting thing that's come up from this process. We're still at an early stage of the AOV reviews, and quite a lot of what is happening is looking, or should be, is looking at the existing setup, and that potentially there was a criticism from the FCA saying in a number of cases this didn't happen. It was everything that was there was taken as okay, and you go straight on to what's changed over the last year. So the baseline means you go back and you look at the classes. You say, are there too many classes here? Which a lot of people came to the conclusion there were, and maybe that's a rather obvious score when on something that should have happened before. But yeah, we've done it. They will look at things like obviously the level of fees, the use of economies of scale, and various other quite structural matters, which can result at this stage in some fairly significant changes. Nothing massive, but a significant repositioning. If that hasn't happened, then maybe it's a reason to look a bit harder. If it has happened, then it may well mean that the next few years actually there's not that much more to do, because things running on a fairly even keel, and it's just a case of making sure that it doesn't stray off course. Has anything changed? Certainly, if you read the reports, it's quite difficult, but hidden in there are, because they're written frankly as a advertising exercise, but there are things changing, of which the changes to classes is a very prominent example, and that does suggest that things are going well. Particularly at the larger end of the funds market is a more visible one for the regulatory purpose. So it's easier to see what's going on there. I guess the FCA historically would say, yes, we expect a higher standard in reality from the larger funds who are controlling more retail money, and we might possibly be a little more tolerant with smaller funds who simply don't have the resources to do this. But that may be an issue in terms of both what should the FCA do, and to what extent are the smaller funds at a disadvantage in doing all of this. I've touched on quality of disclosure, which I think is, not quite sure where that's going to go. I'm not convinced that the disclosures, the reports that are being issued, have quite the same value as the dynamic interaction that you get under the American system or the offshore system between directors and managers. The FCA in its report was adamant that it thought disclosure was a good thing, and I have to say for years and years, I've seen disclosure not working in any number of markets. If they're retail markets, if they're professional markets, it's a different matter. But in any case, this is a work in progress, and there's good reason to think that in a few years this will have become much more established and much more regular, that the INEDs will be fully on board with what it is that's expected to them. The ACDs will have a standard plan which they work through, and it'll all be working pretty smoothly. Thank you.
Thank you, Richard. Thank you for that optimistic perspective. I'm now delighted to welcome Mark Dillon. Mark is also a partner of Dechert, but at Dechert in Ireland. He has a particular focus on Irish regulated management companies and funds, and also international funds in many other jurisdictions. So Mark, over to you.
Great, Roger. Thank you very much. So I'm always delighted to see such a strong Irish representation on the panel. But just to avoid too much overlap in terms of the content that we're going to cover, I'm going to cover my area at a relatively high level and maybe give some background to the development of independent directors within Ireland, and how it's sometimes developed organically and sometimes with a bit of impetus from the regulator, and then leave some scope for development of those thoughts, I think, and areas later on in the discussion. The first thing I was going to focus on related to taking a step back and looking at which board the independent directors are sitting on, whether it's a fund board, a Manco board, and what was very popular in Ireland, particularly in UCITS funds, the retail flagship within Europe, were self-managed fund boards, where it was a hybrid of both. So even within that, we would need to consider what role an independent director would have, and whether it's at the Manco board level, where you're subject to a lot of the central bank's regulatory obligations, or whether it's the fund level, where you're essentially overseeing the job that the management company is carrying out. And there can sometimes be blurring of those lines, but it's important that directors understand that role, and particularly where it's developing out of an area where there have been boards that have been essentially won and may have essentially mirrored the boards on their fund boards and Manco boards, particularly where the proprietary funds, that is often the case. So it's important, as Dick referred to, you may end up overseeing yourself to a certain extent. So it's important that directors, and particularly independent directors, can understand that and are able to carry out their role, in lines with expectations around independent directors, notwithstanding that there are obvious conflicts which occur all the time. And I think the most important thing for directors is to be able to understand that conflicts of interest happen all the time. Everyone has a perspective, but it's been able to identify those conflicts and manage them appropriately. And I think we're never going to get to a stage where we're completely eliminating conflicts. And in fact, there's an understanding that it's a positive thing that representatives of investment managers sit on fund and Manco boards, but we all know there's an inherent conflict there. But it's something that's managed and is an important part of how funds operate, because without the investment manager, often they're often the promoter, and without them there wouldn't be the product. So just it's important to make sure an appropriate balance is struck when we're considering these points. And maybe taking a step back, even then, before there was any regulatory focus on independent directors, Ireland as a funds domicile, but not necessarily an investment management domicile, would have had almost organically had independent directors in place, because there was a requirement that 2 Irish resident directors be appointed to any fund board. And what that often meant, when the investment managers were based in major fund jurisdictions, in such as the US or London or in the Far East, they wouldn't necessarily have their contacts within Ireland to know who to appoint. They would have relied on the service providers within Ireland, and often they would have proposed independent directors. And so you may have ended up with a fund board that, incidentally, just because of the requirement to have 2 directors, would have ended up with 2 directors which would have been independent. Now, that was the assumption at the time. When the Corporate Governance Code came in, there was more of a focus as to what actually is independence. And with that focus, it would have been concluded that actually a lot of directors who would have been considered independent at one stage were not necessarily independent, because they may have also been representatives of service providers. So they may have been a partner in a law firm advising the fund. And while that might have been seen as independent prior to the Corporate Governance Code, there's a lot of focus on that and guidance as to what actually being independent is. So the Corporate Governance Code is an industry code. So it's an Irish funds code rather than a central bank code. But it was introduced in 2011 on a comply or explain basis. So technically, it didn't have to be adopted by funds or management companies, but and even when it was adopted, you could decide not to comply with certain elements of the code. You just simply need to explain that in your financial statements or on a website. Now, there was a lot of engagement with the central bank around this, and there was always the threat hanging over the industry that if it wasn't widely adopted, that the central bank may make it a more prescriptive code and would require the industry to comply. So I think because of that, and maybe because they thought it was a good thing to do and saw that all of their competitors were doing it, we've basically seen all funds and management companies adopted. I've very rarely seen anyone not adopted. What the Corporate Governance Code did, apart from introduce a lot of sensible guidance around governance of funds, it put a lot of spotlight on what an independent director is. And its definition of what an independence is the ability to exercise sound judgment and decision-making independent of the views of the promoter, the service providers, political interests, or inappropriate outside interests. So that's a very broad definition, and it essentially put it on boards to decide whether a director was independent. It would also set out in its Q&A accompanying the code some guidance as to what needs to be taken into account. And there's a number of elements that were suggested to boards, but the main one was that if you are compensated directly or indirectly in any manner outside of your director fee, then that would make you no longer independent. So that had a big knock-on impact at the time. It meant certain directors had to come off boards because they were no longer considered independent. Now, the Corporate Governance Code simply said that you only need one independent director, so the threshold is relatively low. So even one of your Irish resident directors could be independent, and the other not necessarily independent. So that was the starting point. And to be honest, up until recently, there'd been very little change around that, and the industry was pretty comfortable with that. So the question that is being discussed at the moment is whether the Corporate Governance Code itself needs an overhaul. It's now 10 years old. Things have moved on a little bit. I think the central bank is becoming a little bit more involved. As I said, it was involved in terms of consultation and engagement around the Corporate Governance Code, but it's now getting a little bit more involved in terms of dictating what it sees as independence and what the shortcomings of the Corporate Governance Code are. Maybe, Lisa, we go to the second slide, and I'll just talk about the recent central bank focus. As I said, I'm not going to go into detail on what the central bank's fund management guidance is, or more colloquially named in the industry, Cpi Cvi. It is very large set of guidelines, and goes into a number of different areas around oversight and reporting. But one of the elements that it did focus on was introducing the concept of the organizational effectiveness director, which is required to be an independent director. Now, what it did was this organizational director has a number of obligations, and it was quite a challenge for independent directors to take this on. At the outset, there probably was fair to say an underestimate. It's probably fair to say there was underestimated the level of expectation that was going to be placed on the independent director. So it may have been taken on by some independent directors with a little bit of ignorance as to what it would eventually become, or even some would say was when the guidance was introduced. But I think some felt that it was going to be very high level and there wouldn't be the granular elements which now we're seeing expected by the central bank. So just at a high level, the organizational effectiveness director is tasked with keeping the effectiveness of the organizational arrangements of the company under ongoing review. Should be a change leader, bring proposals to improve effectiveness, and it has some very broad responsibilities. And just three of them I'm going to mention are monitoring the adequacy of a fund management company's internal resources to its day-to-day managerial roles, reviewing the organizational structure of the fund management company and considering whether it remains fit for purpose, and considering the conflicts of interest affecting the fund management company and investment funds. Now, that's only 3 of the 6 areas, but when you look at that, you think about how broad the obligations are there and how potentially burdensome they are. And I think that's probably why independent directors felt, well, we'll just have to look at that from a helicopter perspective. We won't necessarily need to get into too much detail. But as we'll see from the thematic review that the central bank carried out, or certainly published its letter last year, the expectations are a lot more than that. They want to see a lot of engagement from the independent director, or the organizational effectiveness director, who is often the independent director, and in fact is required to be an independent director. They expect there to be at least quarterly engagement with the designated person. So, you know, I think there was many thought there might be on an annual basis they'd engage with the manco or the designated persons who are essentially like the employees of the management company. But we'll see actually that it's expected to be far more than that, and they do expect you to get under the hood and look at what's been done within the management company, be on site, have a look at what's happening within the management company, and actually speak to all of the individuals. So it's a big ask for an independent director. One of the other points raised in the Cpi 60 matter review were the areas of tenure and diversity, and how they play into independence, and whether you require a bit of diversity on your board to ensure or to fight groupthink, and whether necessarily the independent director should add to that. The other point was tenure, which is quite a controversial topic, particularly amongst the INEDs who've been in situ for quite a long time, feel they're doing a very good job and are probably appreciated by the management companies. And now they are being told they are no longer independent, or potentially no longer independent. You know, it can be difficult to necessarily say definitively whether they are, but certainly it raises that presumption. And independent directors now are looking at the point either of saying, I need to come off that board, or whether I can convince the promoter to add another independent director to cover that responsibility. So the other point then is that the central bank is getting more involved in this area. And while they've been more, I would say, hands off in terms of letting the board decide with some guidance as to who is independent, maybe with other regulators becoming more involved in the area, they may have been decided that actually it was appropriate for them to get a little bit more involved in this space. And even last month, we've seen them split out the previous pre-approved control function of non-executive director into non-executive director and independent non-executive director, which indicates that the central bank now intends to pre-approve who can actually be an independent non-executive director, which is a recent departure, only published by the central bank last month. So it'd be interesting to see how that develops and what the expectations of the central bank will be around that. I know I'm probably gone a little bit over my time, so we'll just go to slide 3, and I can touch very quickly on the practical impact on boards. I know I've mentioned on the last slide was the disruption to existing boards. A lot of boards feel they're doing a great job already. They wouldn't necessarily go as far to say they resent the implication that they are certainly they're no longer independent. As Dick said, most of them are professional directors. They see that they feel that they're doing a very good job. But I think what the industry body and regulators are getting at, people can be very comfortable on the boards and are doing a great job, but to ensure that things don't get too comfortable and to make sure that there really is proper independence there. So the potential loss of institutional knowledge is a really important thing. I think people need to take a step back and just make sure they don't throw the baby out with the bathwater, particularly if there is a director who's been on there for a long time, and just consider what they bring to the board, and whether they can add another director and keep that, or whether they really need to just rotate, and notwithstanding that they'll lose a little bit of institutional knowledge, that it's a positive thing in the overall picture of things. And then I've already touched on whether it's a realistic burden on individual independent directors. It's likely the way things are going, that burden is only going to increase. And I think I think all the 2 points, time commitments and the additional costs, are related, so I'll deal with them together. It's really about resetting expectations. So we've had a number of very good, very capable independent directors that probably sat on quite a number of boards. The time commitments were not as demanding as they are now. So they probably didn't feel they needed to devote as much time to each role. that is going to significantly increase. Independent directors it's going to be a lot more asked of them. They need to disclose their time commitments not only to the board but to the central bank. So they will need to consolidate their relationships, particularly the directors that have a particularly large portfolio of directorships. And then you need to consider what the additional cost of that is. Often independent directors, because they have a number of relationships, haven't necessarily charged that much to the fund in terms of their role. But if they're being asked to take on what is essentially quasi-employment by the fund, they may be looking for more compensation around that, because there is an opportunity cost to the time commitment that they need to devote to being a truly independent director. So sorry for taking up a bit, probably slightly more time than I was allocated. And back to you, Roger.
Mark, thank you very much. I think it's very useful to have that contrast with how the situation is operating in Ireland compared to the UK. And it's just really interesting to hear about the breadth of the role and the ambition for the role that the Central Bank of Ireland has. But thank you, Mark. I'm going to turn now to our next speaker, Professor Blained Clark, who is Professor of Corporate Law at Trinity College, Dublin. She researches across a whole range of areas, from company law to corporate governance, ethics, and financial services law. And I'm very interested to see that she also sits on the OECD Corporate Governance Committee, as well as a variety of other boards and advisory boards, both at EU and national level. Blained, over to you.
Thank you, and thank you for the invitation to speak here today. So I am going to just delve into a little bit more detail in some of the areas that Mark has talked about. I'm going to show you the detail of the requirements or the expectations on INEDs from the central bank. And having reviewed the really excellent paper that Iris and Roger produced, I wanted to look at their characterization of independent non-executive directors as individuals who are, have a welfare watchdog role, assisting in investor protection and responding to that sort of a social need, or asking whether they're really there to provide an additional safeguard, a procedural safeguard, to perform a sort of a signaling or information role, as they describe it, particularly in the context of allowing investors to determine whether they want to exit. I wanted to look to see whether the challenge which is being demanded of INEDs in the Irish context really focuses on processes and framework, or whether it's on outcomes, or, as I suspect, it's a mixture of both. And then, if time allows, I just wanted to mention one development in relation to accountability. So what you'll see here is the code that was mentioned by Mark earlier, the funds industry code, which defines, as Mark explained, the requirements in relation to independence. I think a couple of other points worth mentioning on this code, particularly given that it was introduced at the behest of the central bank, but also it involved a lot of input from the central bank. So the idea was that the INEDs, at least two of the directors, one would have to be an INED, would be reasonably available to meet the CBI at short notice if so required. So this was somebody that was accessible and could communicate in a very ready way. Now, obviously, this was operational on 2012. Being reasonably available in a remote world means something quite different, but it does give you an insight into how the CBI or the fund industry characterize this particular role. There was a question I noted in the Q&A about the overlay between the expectations of the industry and also directors' duties and statutory duties in Ireland as well as the UK. So interestingly, what the fund governance code says in this respect is that while all directors owe a duty to act independently, having regard to the interests of the fund and the investors collectively, independent directors represent an additional layer of oversight of the activities of the fund or the management company. So this is an additional obligation, and you'll see that referenced throughout CBI communications as well, the idea that this complements what's already there and standing. At the outset, we talked as well about the expectations for experience and knowledge, and that's set out quite clearly. The independent directors have to have knowledge and understanding of the objectives of investment, also the regulation of the industry, policies and outsourcing arrangements. So there is a requirement there that these be people who are both qualified and experienced. And that's soft law, if you like. So moving then into the realms of hard law, you look to see the regulations. Now here I'm looking at the rule book for the alternative investment fund managers, giving effect to the directive. And as you all know, that imposes obligations on the companies to act in the interests of their investors and to act in the interests of the funds. But in addition, it allows additional obligations be imposed by the CBI. So in their rule book, the CBI go further. They mention the organizational effectiveness role that Mark mentioned. There's a little bit more detail I'll come to in a moment in guidance. One thing I thought might be interesting, again, just focusing on the idea of directors' duties, is there is a provision in there relating to resignations, and it says where directors plan to resign from their funds, from the boards, they need to communicate it to the CBI. And where a manager manages a fund which is in distress, there's a clear statement that the CBI expects the directors will not resign if it's not in the interests of the AIFM or its unit holders. And that's a very strong statement there. And they go on to say that it's not the CBI will view the departing director as not fulfilling their duty to the company if it goes against the ability of the fund manager and the CBI to resolve a prevailing issue. So that's very much, I think, a welfare role or a note to that in the context of the article. Moving then to CBI guidance, and this is the Cpi 86 that Mark talked about. And the idea here was acknowledging the success of the fund industry being very much based on, as Mark explained, delegates to ensure that there was good governance and effective management. And it's a very broad list of stakeholders mentioned there, the protection of investors, but also market integrity and systemic stability. So this Cpi 86 has extraordinarily detailed rules. So what you have on this rather busy slide, and apologies for that, is an insight into some of those requirements, just to give you an understanding of the detail that's set out there. Some of it will be familiar to those of you who have read directors' duties recently, and the statements and the guidance that are set out in corporate governance codes or indeed in company legislation. So firstly, directors should be attentive to their duties. They should have sufficient time, and that's measured. They should exercise skill, care, and diligence in the continuing oversight of the delegates. And this comes to the idea we talked about earlier at the start, about what sort of information. So it said, well, the boards should receive and ensure that they're satisfied with periodic reports, but it goes much further than that. It says that there must be openness and engagement and cooperation and dialogue between the board and its delegates. So it's not a question of present a report and rubber stamp it. And there's very detailed explanations, really, of what's required in that context. Back to this idea of expertise. It says the director should have an understanding of all aspects of the investment manager's business and policies. And what I've done is I've just taken some of the areas that are the focus of CP 86 and just extracted the requirements for the boards and the INEDs, particularly in those contexts. So for investment managers, it says clearly that requires site visits or meetings with senior management. And that is very much the expectation, that you will travel and not just accept what is presented on a piece of paper. Not just to prepare for the board, but as it goes on to say, proactive monitoring of the developments between board meetings. So this is very much a constant requirement. This is not a turn up just to the meeting and read the papers beforehand. It's a much more onerous obligation. In terms of regulatory compliance, the board should provide input and constructively challenge proposals. And you'll see that requirement throughout CP 86 and the guidance and the speeches: challenge, challenge, challenge. I wanted to just give you an extract from the provisions in relation to the Director of Organisational Effectiveness that was referred to earlier. And again, there's a non-exhaustive list of what's required for somebody fulfilling this role, and it is indeed a particularly onerous role. But these are three that I think are interesting in the context of today's discussion. So the director should suggest proposals to improve board effectiveness, and not just suggest them, but should ensure that they're implemented. So a very proactive and confirmatory role there. They're responsible for reviewing the composition of the board, so ensuring the diversity that was referred to earlier, that is reflected on the board. They're also responsible for periodic board effectiveness evaluations. They are also responsible for overseeing how well the decisions taken by the company and the arrangements for the supervision of the delegates are working in the interests of investors. So that's useful because that's the link that I think was referred to in this paper about ensuring that there is a link to the substantive outcomes. And this very much is an acknowledgement of that link and of that responsibility. I wanted just to refer to a really useful speech. I think anyone trying to get an inkling of how the CBI view this role and the expectations should have a look at this speech by the then head of asset management area, Michael Hudson, in October 2019. And this sets out very clearly how the CBI consider the INED plays a role on this board. And as I say, performs that dual function. So they talk about the importance of INEDs bringing objectivity, bringing fresh ideas, using their knowledge and experience to ensure that there's good governance in the firm. Also ensuring that they operate a sustainable business model with the client-centric focus. So the nod to investors in that respect. And the title of this was The Spirit of Challenge and Responsibility. And it's very clear that there is a huge expectation, not just to do this, but to be able to demonstrate that they are doing this, to demonstrate to the CBI that they have satisfied their requirements and their duties. He breaks it down into what he describes are the three elements that INEDs have to demonstrate. And the first is challenge. He said, it's imperative that you hold the board and senior management to account. And he describes that as the core of the role of the senior, of the INED, to hold the board and management to account, to embrace the responsibility to challenge, to ask the hard questions about the quality of the information, the strategic direction of the firm, the culture that prevails, and the risks. In terms of independence, he says, you've got to maintain independence to perform this distinct role. And he says, this is different. it's really important that we have people who don't think like executives. And this will be a source of strength by providing robust challenge and an independent counsel. And then he mentioned the importance of diversity, reducing groupthink, enhancing risk management, and reducing overconfidence. So issues we've touched upon. He also mentioned hot topics. And I think this was interesting. In the paper, there's a reference to the trend towards a more elastic and wider expectations of INIDs. And you certainly see them here. If you look at the list on just the last bullet point there of what's expected to be covered by directors, what they should be engaging with. And there's quite a bit of information at each level. But just to touch perhaps on one that Iris mentioned, the sustainable finance. He said that directors, INIDs, must be alive to developments in these areas, and we're all aware of how broad that is. To consider their implications of these developments, what steps need to be taken in the firm to contribute to the development of a more sustainable financial system. So a very broad scope there, and a lot of expectations. I'll just move quickly through this. This is the report which was produced, the thematic review that Mark talked about. And they said there just wasn't enough evidence. So taking the example of new funds, there was no evidence that the board had, in many cases, had engaged in a robust discussion and challenge. Often they came in late in the day, just prior to the launch, and they didn't engage with these. They didn't discuss the strategies and structures and the risks in a really detailed way. And the suggestion was they need to be doing this much earlier. As you'll see there, they were very critical of the DOE role. And they said, look, you may be doing this, but there's no evidence you said you were satisfied that in cases that there's sufficient resources. Well, where's the evidence? Where's the records of the meetings? Where's the evidence that you've considered the conflicts of interest? Where's the formal reporting to the board? Where's the minutes to indicate that the board really grappled with this? So this was a real criticism of this particular role. The fund managers and their firms were sent back to come up with a plan to mitigate these risks and to improve issues. I won't go into the governance and culture trends. I think Mark has covered that, but these are the particular issues for you. They were very critical of the tenure, as Mark mentioned, but also board diversity. I wanted, just in the 30 seconds that are left, just to mention one thing. INIDs will be really conscious of a piece of legislation coming down the track, which is the SEER regime, the Senior Executive Accountability Regime, which is like the senior managers regime in the UK. And as you'll see there, it's got maps, it's got statements of responsibility, it's got a duty of responsibility. But one big difference is that in this case, it's likely that all non-executive directors, so all INIDs, will be brought within that list, not just individuals who are chairing committees or the chair of a role. So I think that's one huge difference between them. Okay, so I will stop sharing there and turn back to you, Roger. Thank you.
Thank you, Blaney. That was incredibly useful. And you really, from a UK perspective, you really have contrasted, what the Central Bank of Ireland is trying to achieve with what we currently have in the UK. That they seems to be like a world apart at the moment. Well, thank you for that. And let me now turn to our final speaker, Dr. Margaret Cullen, who is a specialist in corporate governance and in investment fund governance. Margaret, I know that you've taught these subjects at the Institute of Banking and at other academic institutions over many years, and you've served also on many boards in the financial sector. And I should also mention that Margaret serves as a board assessor with the Institute of Directors in Ireland. So Margaret, over to you.
In terms of my discussion today, so I'm having problems with myself. It's moving along. I want to start because I'm notoriously a bad timekeeper, Roger, and you're going to have to keep me very honest. But I will say that there's some key takeaways that I want to belt home at the very beginning. You know, I left industry in 2006 to do a PhD in this area because I saw the direction of travel, particularly of European regulation, and it concerned me hugely. Europe, unlike the US and the UK, have a very unenviable task, and that is to regulate investment funds where the manufacturer of those funds isn't domiciled in Europe. 80% of funds domiciled in Europe have non-EU IMs, okay? And that has always created a huge problem for European regulators and de facto the national competence authorities that have to enforce or to enforce European regulation. The US don't have that problem. The UK don't have that problem for UK domiciled funds, and it's a very significant difference. And in my view, has had a significant influence on a lot of the regulatory policy that emanates from Europe and indeed from within the NCAs. But one of the things, when I started my PhD, I did a wonderful module on the theory of rule and rulemaking as a preemptive strike to my academic research. And one of the first things that the professor said in class was that regulatory policy that doesn't reflect the practical reality of the sector it's trying to regulate will not achieve its objectives. And in my view, and my humble view, I think we're in a situation where certain regulatory policies that are in place are really setting INEDs up to fail and fund boards up to fail. I really believe in the importance of an INED. I really believe it, but I believe that the importance of an INED needs to be placed within the context that's realistic. And that's probably a key feature that I'm going to talk about today. I want to make the point that my opinions here are my own personal view, not of those of anyone that I deal with or on whose boards I sit or necessarily. They're my own personal view. And the views here are taking a very jurisdictional neutral view of the world, but I hope that they will be helpful to the myriad of jurisdictions that are on this call, because I know that there are people from a number of jurisdictions. So fund boards should be evaluated against a role set consistent with the practical realities. Okay, and it's really important that certain jurisdictions and you know, in Europe, I've talked about the problem, and what we see in a lot of jurisdictions is we see, you know, an understandable emphasis of national competent authorities, probably led by the European framework, to have substance on the ground. That substance on the ground, you know, that, you know, if the product originates in Europe, it must be managed in Europe. And so, you know, we've seen that evolution. And, you know, I have sought heavily to influence regulatory policy over the last 15 years. I've failed miserably. But the one thing that I will say is that if you find yourself in Europe sitting on a fund board, or you find yourself in the US sitting on a fund board, and you know, the UK is very different because INEDs do not sit on a fund board, they sit on the ACD, and that is really, really important. They sit on an ACD. And so they have a duty, they've got the regulatory overlay of what the FCA asks them to look at, but their duty is, outside of that regulatory overlay, their duty is to the ACD itself. And that's quite different to the US, very different to the US, in fact. And I was very interested in Irish comments, because I would imagine if there is additional regulatory overlay, it'll be interesting to see how that all marries. Okay, so they're key takeaways. But what I wanted to do is I wanted to focus, if I may, on the reality versus the regulation. So we've heard, for example, we've heard from Blonid, we've heard from Mark about the significant emphasis being put on fund boards and in particular the INEDs. You know, from an OE perspective, we know the responsibilities that are imposed on INEDs in the 1940 Act world and so on. And indeed on INEDs of ACDs, who are appointed to OEICs in relation to assessment of value in the UK. But let's just look at the economics. Now, I want to be very clear, when we look at the reality here, if you take a look at a P&L of a fund, it tells you everything you need to know about who's running the show. And at the end of the day, I'm not opining on whether I believe that 85% of expenses out of the fund should go to the IM. That's not the issue. It's a significantly important economic function that IMs provide, excuse me. And I think that, you know, the question of whether the fees are too high is beyond the scope of this particular session. Let's just look. It's quite a crude reflection here, but I hope you get the message. On the left-hand side, we have the P&L, okay, with the fund board typically getting less than 1% of the fees from the fund. On the right-hand side, we have the regulatory emphasis, and all of the emphasis being put on the fund board, and you see about, I would say, garner about 85%, or you would of the emphasis. And let's take a good example. Woodford's been mentioned, the Woodford Equity Income Fund. Now, this is just an extract from the Daily Mail in October 2019, and there's a lot of fluff around here that I don't really want to look at. But if you look at the level of fees that went to Woodford in the first instance, and then you look at what was lost by investors, it really begs the question about whether the FCA was asking the right exam question and focusing on the right things. So it's a really good case example of where the regulatory emphasis, in my humble view, was misplaced. Andrew Bailey was required to prepare a report in relation to the WEIF to the chair of the Treasury Committee. And he wrote, in the case of WEIF, which was first authorised by the FCA, the fund manager is Link Fund Solutions Link. The Link was the external ACD. Let's remind ourselves, we can, there are so many different models of governance right across the globe in what is a global industry, and we want it to be a global industry, and we have so many different models. In the UK, you've got internal AFMs and ACDs, you've got external ACD and AFMs. In Europe, we have internal mancos, we have large internal mancos, we've got small internal mancos that are more regulatory enablers, we have external management companies in Europe that are definitely regulatory enablers. So, in this context, Link Fund Solutions was an external ACD. And the fund manager has, according to Mr. Bailey, the regulatory responsibilities in relation to operating the fund, and therefore for Woodford Equity Income Fund, Link is accountable to the FCA. How much do you think Link earned for that regulatory risk? And how much do you think that the INED earned for that fiduciary risk? And I think it's a rhetorical question. You might Google it and find it, but I think that you'll be very interested when you see when you take a look. So I think it's really important, Iris mentioned the point around, how the FCA will evolve in its thinking of INED structures. I suspect for a lot of for a lot of regulators, they're so far down a corridor, it's very hard to come back. But I think it's really, really important that we remind ourselves of the context. And this is context that's often ignored, and very frustratingly so. I spent 5 years immersed completely in the literature, immersed completely in a qualitative review and a qualitative based research into what makes effective boards. And the golden question was boards that protect the interests of the investors. What is it about the fund boards that will protect the interests of the investors? And one of the things that we often forget is an investment fund is a product. It is a product of the investment manager, okay? What it has is a very unique characteristic, and this is a very unusual legal pecking order with the fund at the top, and depending on your jurisdiction, you might be obliged to appoint a management company, which is the way Europe is evolving, and then the management company might appoint the investment manager. In the UK, you might be obliged to have an ACD, or you've got to have a director of your OIC who then appoints the investment manager. So the suggestion, the legal pecking order suggests that the fund appoints the manco, who appoints the investment manager, or the fund appoints the investment manager directly. That legal pecking order creates huge challenges because it doesn't reflect the reality. Okay, so what I would say to any policymakers out there, start looking at the reality. Are we so far down a corridor that we can't come back? And that's one of the big questions. US academics for years, both legal and other finance academics, have been challenging the 1940 Act regime. Kicked off this legal pecking order. It's very interesting that you might know a little bit of an interesting fact, but the 1940 Act regime, the construct that predated that was a legal entity that was set up for venture capitalists. So for venture capital investment in companies, and then it morphed into collective investment scheme in the 1940 Act. So, there's wonderful literature from the US academic world that actually really challenges that this morphing into the 1940 Act world that has influenced so much of that legal pecking order that we've all become accustomed to. Okay, I mean, investment funds often viewed by regulators as a mirror of the corporate governance model. I mean, we've heard terms like the Corporate Governance Code for funds in Dublin. It's not a corporate, it's a fund. When you start thinking about a corporate, you're thinking of it, in my way, incorrectly. We have a lack of global consistent regulatory approach to fund governance. And in my view, as I said, unrealistic expectations on the INED. I think it's really, really important to remind ourselves that investment funds do not and cannot operate in isolation from the IMs that establish them. So if I go back to a Woodford scenario and the blame being put on Link, I'm saying, well, fair enough, if Link signed up to that, okay, you know, they're going to get a bit of the blame. But at the end of the day, the FCA needed to look at Woodford and say, how was that governed? How was it run? What was the board of directors doing? What was the internal governance framework like? The 3 lines of defence? How did they manage liquidity risk? How did the first line manage it? How was it overseen by the second line? What third line assurances were made? That's the governance. That's the product governance. And the fund board will add an extra dimension of governance, and help us not mitigate, because we cannot mitigate conflicts of interest, but maybe help us manage it with investor protection lens. So my view is that you cannot divorce the fund from its product. The same way as I don't go out and decide I want a Mercedes CLA, but actually say I want BMW to make it. Okay, you know, the product is inextricably linked to the investment manager or promoter. Investment fund governance is all about investor protection, and this must happen first and foremost within the IM, and then at the level of the fund. But it begins and ends within the investment manager, the same way as if I produce a car, the manufacturer, which begins within the manufacturer. In bullet point number 3, I mentioned the issue of a mortgage. And I know mortgages, I'm picking it because it is a retail product. It is something I know that actually interesting, you know, if the bank is the mortgagee in the context of a mortgage. But let's just, for simple purposes, you know, remind ourselves that, you know, banks engage and offer mortgages to retail customers. Within a bank that offers a mortgage, a bank has to design a product. It has to consider the contract risk aspects. It has to consider prudential risk aspects. It has to price for its risk. It has to make sure that the product is appropriately sold and is appropriately managed. Why are investment funds any different? Why do we suddenly think, just because we have this legal framework at the level of the fund, that suddenly it's an INED responsibility? Okay, and again, I keep going back to the Woodford example. Mark mentioned it, I fully agree. INED representation on fund boards, to me, is an absolute no-brainer, because you're taking the product producer and you're putting them on the fund board. And you know, so for me, I mean, I certainly would love to see in the UK the OIC evolved to have independent non-exec directors. I got to say, I'm sorry to say, I'm not a big lover of the ACD model, but then I'm not a big lover of particularly the third party, but then I'm not a big lover of the third party Manco model in Europe, and that's no secret. And I've mentioned conflicts of interest, and in the interest of time, I'm going to move on because I'll pick some things up later on. So in the context of fund boards, what I would say to every fund board out there, whether you're a 1940 Act fund board, whether you are a SICAV in Luxor or an ICAV in Ireland, whether you are an ACD who has this responsibility, okay, within fund boards, I think it's really important that you really realize how significant the culture of the investment manager is. And I think it's an abdication of responsibility of any regulator not to focus the lens on the product originator and look at the P&L of the fund and remind ourselves how significant the investment manager is. But let's be very clear here. If I'm an investor and I buy into an investment fund, I am buying the expertise of the investment manager. I am buying the track record of the investment manager. I am buying the prospect that the investment manager gives me in terms of returns. Okay, the prospectus outlines the investment strat. The prospectus outlines the investment objective and all of the risks inherent in the investment fund. I'm buying into that risk, and I should be able to assume that that risk has been managed by the investment manager on a day-to-day basis, or service providers that the investment manager has selected, not the fund board, that the investment manager has selected, because they have a global relationship with them, and or they've done due diligence on them and they monitor them on an ongoing basis. But the critical thing for me as a fund director, if I'm sitting on a fund board, is I'm asking myself the question, is this a culture within the investment manager that I can buy into? Does the investment management take, as part of their overall governance, does it take product governance seriously? Can the IM demonstrate that it takes governance and investor protection seriously? So INEDs, do your due diligence on that. And if you don't do your due diligence, I wish you luck. Okay. It's critical that IMs and investment fund boards are clear also as to their objectives and the principles of investment fund governance. I do this in class all the time. I ask directors who are sitting around the table, what's the objectives of your fund board? What do you understand by investment fund governance? And the myriad and divergence in responses is quite staggering. So you know, we need IMs and fund boards need to be very clear about what they're trying to achieve when it comes to fund governance. Remember, investment manager is looking to grow its business. That's corporate governance, direction and control, growing its business in a risk appropriate way within an agreed risk appetite. Fund governance is about investor protection. Okay, and the dominant role of the investment fund board can only be oversight. It cannot be control. And you know, I've written extensively on that, but I'm not the only one. There's plenty of reading, and I'd be willing to share that reading with anybody that wants to hear it. But there is a risk to a director and to investors in asserting that you have more of a control than you actually do. So I think it's really important that every fund board, and I say this even to an ACD as a corporate director of an OIC, understand the risk. What is the risk that the investor has bought into? Okay, what is it bought into? What are the contractual arrangements? Who is appointing who? In the next slide, I'm going to talk about simulating when something goes wrong. And in that scenario, when something goes wrong, is the investor protected? So we've got this legal pecking order. How does the contractual arrangement enable the fund board to protect the underlying investor? You go from contractual arrangements to service level documents or agreements, okay, to make sure it captures who within this ecosystem is managing the risks that the investor has bought into on a day-to-day basis, is actually doing the day-to-day management, not T+3 post-event checking, is managing the risk, front line, second line, okay? Oversight impels fund directors to ask whether the IM and service providers, such as the administrator, have appropriate systems and processes in place for identifying and analysing and managing risk. And fund directors should understand how risk management systems work within the IM and service provider organisation. We want clarity on respective liabilities and accountabilities. And the key question is, you know, this isn't the case that we're accepting things blindly. We create the basis for reporting that comes to the board. We engage with our service providers and the investment manager to create the basis for reporting based on who we know is managing the risk. So show me the KPIs, show me the KRIs. From where do I get assurance to know that the investor is safeguarded? I'm a firm believer in the investment fund board leveraging, not duplicating. You know, when we're duplicating, we're adding cost to the investor. Let's make no mistake about it. Okay, I'm a strong advocate for a risk-based approach to investment fund governance, as I've mentioned, and the IM is critical in that regard. I don't have time to go through it, but very happy if anyone ever wants to talk to me on a just a general basis on the notion of one process to many in terms of funds under management. I've mentioned the simulation of what can go wrong. I ask you in your current fund boards, simulation error, simulate something. When something goes wrong, the focus of the investment fund board must be on protecting the interests of the investors. Is there an economic loss to the fund or to the investor? Who is required to make that whole? Remember, risk failure drives losses for investors, okay? And I would strongly advocate that having a very strong, robust risk-based framework enhances the board's ability. But it's really, really important we focus our lens on who is actually managing the risk. Okay, regulatory compliance within jurisdictions. I mean, you've got to be regulatory compliant, and you know, I thought, you know, not that I would ever fight against regulatory compliance, but my big assertion always is that I will not, if I suspect that being regulatory compliant is obfuscating my capacity to do my job as a fund director, you know, I feel I'm failing in my fiduciary duty. That I need to make sure that as a fund director, I have the capacity to protect investors. There's been much talk about independence and independence criteria and so on. I know directors who've been on fund boards a wet week and they wouldn't know independence if it came up and slapped them in the face. I know people on boards for a lot longer who are sharp and critical and challenge and so on. You know, for me, relying on the 3 I's of governance is something that I always preach. And with a colleague of mine, Frank Ennis, we speak about the 3 I's: integrity. The most important thing is you don't compromise your integrity, that you demonstrate an independence of mind. But when I talk about the 3 I's of governance, this is not just about independent non-exec directors. This is about the investment manager at both the IM level of product governance and both at the fund level of product governance, standing back and saying, is this in the best interest of investors? Okay, and the most important part for me is intelligence. Don't let someone insult it. You know, and you know, I often think that you know, when we think of, you know, if someone's standing in front of me wearing a red dress and then tells me they're wearing a black dress, and everyone around me tells me they're wearing a black dress, you know, I'll still say they're wearing a red dress, and I will try to govern in that context. because I think it's really important that the governance framework reflects the practical reality of the way things roll. Okay, I'm finished. I'm conscious of time.
Yes.
Sorry, Roger. I'm going to stop. I'll leave that
Yes.
that slide there, Roger, just to
Okay.
remind us about what IOSCO's goal of governance framework is investor protection. So I'll stop sharing there.
Thank you very much indeed, Margaret, and well, thank you to all the presenters. And I wonder if we've accumulated quite a few questions. I wonder if I could there's just one question I would like to start with, actually about the UK regime. I think there's quite a lot of misunderstanding actually about how the UK independent director framework is intended to function. I suppose that what people were expecting from the FCA was, you know, we want to have some people who are going to robustly challenge the asset manager. They're going to ask them the tough questions that Blenheim was talking about, you know, constructively challenge, be critical, really delve into what they're doing. But the sort of disillusion which has come through is that they're not really doing that. That perhaps, you know, the people who have been appointed to these positions are industry insiders. They're people who have been appointed there as a kind of sinecure. They're too close to the investment managers. They're never going to really kick up much of a fuss. So as a result, we don't really get that much extra, much of a check and balance coming out of independent directors any more than we have anyway with a regulator. And I suppose another factor there is to whom do they owe their duties? You know, a lot of people, I think, assumed that perhaps they were going to owe their duties to investors, and they would be sitting there at the fund level fighting for investors' interests, when actually it seems that that isn't the case. You know, they're actually they owe their duties actually to the investment manager. They're their legal duties to the investment manager. I just wonder, Richard, maybe I could turn to you first, because you were reasonably optimistic and positive about how things were functioning. How would you respond to that critique?
Well, I can see the point, because there was sort of mixed up with what I was saying, a bit of a concern about the whole ACD structure compared with a pure fund director board, which has its own ethos. You are trying with the UK system and indeed with the ManCo and the structure to some extent in general, to use regulation to replicate the dynamic you get from an independent fund board. But it's difficult to just import an independent fund board into the existing structures we've got, because I'm not sure we've got the sort of quality directors that you're talking about in the UK. I mean, maybe the investment trust industry has got some more of them than everyone else has, but you have to find them from somewhere, and you have to pay them, and probably it's a bit, if you do it to sort of Rolls-Royce standards, it's going to cost more than just running the ACD in the usual way.
Yes, I mean, do you think, Iris, then that given the limitations of the approach that we currently have, that we can even call them independent directors in any meaningful sense?
I mean, technically, I mean, they are independent directors of the board on the ACD or the AFM. And I think that the problem really is industry structure, is the investment chain issue that has been, you know, discussed by John Kay, by a lot of reviews. I mean, the investment chain is a very complicated chain, and there are commentators. I mean, one of them, Catherine Judge in the US, has written very critically about the investment chain structures being designed in order to protect the most powerful, and as Margaret rightly pointed out, the investment manager. And to spread risk and responsibility in such a way across the chain so that investors don't really get direct accountability from the investment manager. I mean, that is the effect of it. I mean, I don't want to go as far as to say that's the whole point of it, but that's the effect of it. And if you rely on industry structure and build in regulatory monitoring mechanisms, then you're just relying on structure, unless regulation cuts across and does something more in terms of imposing cross-cutting duties to, you know, on investment managers. you won't really get a very robust monitoring mechanism out of relying on the structures that are there, put in by the investment chain.
Yes, Blenhead, when you were speaking, it very much touched a chord with me, in the sense that it sounded like the sort of duties you would expect of a director of a commercial company, of an industrial company. The need for diversity, the need for people who come from different backgrounds, to ask the tough questions. But it doesn't, from what I've heard, it doesn't sound as if that is anywhere near likely anytime soon in this funds governance regime.
Well, I think there is an understanding that there is, and I know this was one of the Q&A questions too, there is an understanding that there is a difference between fund governance and corporate governance, and everyone approaching this role understands it. For all the myriad of reasons and the business models we've talked about. But I think there is still a need for expertise to cover the vast range of subjects. And the expanding range of subjects, as was pointed out. And I think that's where diversity has a huge role as well. The board has a collective responsibility, but individuals bring different levels of expertise, and independent directors even more so. So coming from, coming from perhaps one of the service industries, one of the delegates, or somebody now with a greater appreciation of risk management. So I think there is an awareness that there are some lessons that we can learn from corporate governance, but we are very much dealing with a different model. And I suppose just the last thing that I see from talking to fund directors or would-be fund directors is that there is a huge concern as to the ability to understand the different responsibilities of the fund director, where there is also a ManCo, and then the responsibilities of the directors on the ManCo, and how that plays out.
Yes, and Mark, I just wonder whether you foresee, either in Ireland or in the UK, much scope to really expand the oversight areas of responsibility of independent fund directors, to some of these new areas that we were talking about, like sustainable finance, perhaps the stewardship role, perhaps that the investment manager plays, as well as, should we say, the more narrow things like assessing value for money.
Yeah, I think it's a very interesting question, Roger. I mean, there's the scope to what extent you expand the role beyond what it already is, and there is I suppose the inherent conflict of it. You need to be technically very strong to be able to see the issues, and does that mean that you are just choosing your pool of independent directors from a relatively small group of insiders who have a lot of experience within the funds industry, and maybe the baggage that might come with that in terms of, I think as Margaret is kind of raising, it's not necessarily just spotting issues, but maybe challenging the structure that you act within. So it's not necessarily that you spot issues that a particular manager is doing, but you don't necessarily just go on along with the norms that are happening, and you just because you've seen them on another board, you think what that investment manager is doing necessarily is sufficient. So if you are even looking at expanding it to other areas, then I think you do need that expertise, and it becomes a smaller pool to choose from, and then there are more issues around whether they're truly independent. But I think ultimately the central bank would, and probably us industry would see that within the role already. So I think independent directors, certainly the boards we would sit on, the independent directors often, the chairman's often an independent director. The other independent director, if there are two Irish resident directors, are often very experienced directors. They often drive the board meetings and can be very influential in terms of asking the questions around that. So I think they are very involved in those decision and oversight decisions, but the issue is, and I've saw a question come in already about at what point do you start considering them to be a quasi-executive director rather than a non-executive director? Where does their brief start and end? And I mean, that's why there's so much for, I mean, it's so interesting to listen to Margaret talk about. I mean, there's so many issues, and I think, in fairness to the regulators, trying to do the best they can when there have such a distance between, and there is a bit of a disparity in terms of the power that they have. The investment manager is the key person in the decision-making process. They drive it along with the advisors, and the independent directors do oversee it. They usually have the expertise, but they're involved in everything goes to them, but they may not necessarily be involved in the early decision. I think that's what CP 86 is trying to get to, is to try and, particularly around the investment product itself, get the fund or the directors involved at an earlier stage and not just have them essentially rubber stamp it at the end. So while they are involved in oversight of all of that, it's to what extent they actually, and I see someone quoted me when the questions get under the hood in terms of the actual decision making and the assessment process. But
yes,
you could probably talk about this for a long time, and I know we have, but it's very hard to come up with the perfect solution, you know. Yes. And I think there are limitations to every approach.
Yes, Margaret, I wonder if I might put one of these questions to you, which is sort of about the practical functioning of boards and, you know, independent directors making sure that they get the information that they want, you know, rather than being just spoon-fed everything, you know, by the management, being rather passive. Do you have any recommendations in that respect?
Yeah, I mean, I often do get concerned, Roger, when I hear certain things about, you know, you can't just rely on information you get. I mean, Common Law 101, you're entitled to rely on the information you receive as long as the people who are providing it, you deem them to be fit and proper. I think one of the critical things for a fund board is, don't get me wrong, you don't take it blindly, but I mean, if I look at something and I say, you're telling me you're beating the MSCI index by 5%, do I go and check that? The thing is, what you need to do as an INED is you need to create the basis for reporting. You need to be fully aware of the frameworks within your investment manager, the administrator, the custodian who isn't out, you don't outsource, you have to appoint the depository custodian as required. How do they manage, what is their corporate governance structures, how do they manage risk, and create the basis for the reporting in relation to risk that's been managed on behalf of the fund on a day-to-day basis. And I think that, you know, once you create that basis, you are relying, and let's look at it. I mean, you know, when you are a fund board, you're looking at, you're getting direct reports, so you're getting SOC 1s, you're getting SOC 2s. You know, sometimes you might be getting reviews by the IM who's doing vendor management on the outsourced service providers as well. So you're collating all of this. So this is an iterative approach, but you've got to stand back and say, from where do I get assurance? I mean, the discussion around, I mean, my biggest concern is one of the most important things that an INED brings is objectivity. And the more INEDs are getting dragged into the day-to-day, they're compromising the very objectivity they're supposed to bring to the table. I was lecturing last week on a bank director program I run in Dublin, and there was a newly appointed INED to one of the bank boards, never grew up in banking, didn't grow up in banking, completely different industry. Best questions of the day, best questions of the week came from that person. Okay, why? Because they're looking at the world through a different lens. So I would refute the idea that we don't have expertise, because what you need is a bit of cop on. This is not rocket science. This is not rocket science. Cop on, don't let anyone insult your intelligence, bring your integrity to the table, and you won't go too far wrong by your investors.
Okay, well, I think we've slightly overrun in terms of timing, but what I'd like to do is to bring the session to a conclusion, if I may, is just go round the table and perhaps ask you for a final observation, or it could be a piece of advice to the audience, or it could be a plea, a sort of a policy plea to policymakers, whatever you would like to deliver as a final takeaway. So maybe, Iris, could I go to you first?
Right, okay.
I'm sorry to make you first. I realize that that means you have less time to think now than the other people.
And I would just say, I mean, actually, maybe I sound more critical than Richard is with our UK institution, but I think, you know, as a monitoring mechanism, it can still work. I just think policymakers have to think carefully what they want out of it. And perhaps the narrower mandate may work better given the structures that we have.
Thank you, Iris. Richard, how about you?
Well, listening to the Irish presentations, I think the main thing that struck me, and it may be a bit impressionistic, is that the central bank is micromanaging the whole thing too much, and it goes back to what I was saying about, you know, relying too much on process and not enough on a holistic picture. I mean, that may be an unfair criticism, but that's what I was getting. And I also found myself saying, well, actually, independence is not the absolute holy grail at the end of the day if you're sacrificing competence in order to achieve it. So those are my thoughts.
Very good. And Mark, let me turn to you.
Yeah, I think along those lines, I think most important thing is really the judgment and to be able to ask the important questions. So I think there's been a lot of focus from central bank on things like challenge. I mean, that can mean anything to anyone really. And if it's just asking a number of pro forma questions every time something's put in front of you, that might not necessarily add value. But I think what you need to be able to do is spot where the issues can arise and be able to raise issues and challenge when appropriate. So I think what we're doing is, I know it was referred to earlier, is where it's regulator led. The focus suddenly becomes on complying with regulation rather than necessarily looking at what the issues are and how to solve them.
Thank you, Mark. And Lanaid.
Thanks. So I think I would say that the central bank isn't, or my reading is that it isn't asking directors or INEDs to micromanage. It's asking them to check that they have responsibly delegated, you know, functions, and that they've checked to have the controls in place. For advice for an INED, I would say make sure that you have sufficient knowledge and expertise in the area to not only ask good questions, but to understand whether the answers you are getting are good answers, and you need enough expertise for that.
Thank you, Lanaid. And Margaret.
Oh, Roger, I think you probably know that I'm going to say throughout the rule book and let's start again. I think, you know, for me, it's about the investment manager and the governance of the investment manager and how the investment manager is regulated. But what I would love to see, particularly in this global, wonderful industry of such economic significance, I would love to see regulatory equivalence. 80% of funds domiciled in Europe are managed in the UK and US. We need regulatory equivalence. Let the real investment managers please stand up.
Thank you very much, Margaret. That's fighting talk. Excellent. Well, I just want to say a big thank you to all of the speakers. I really enjoyed your discussion. Also, thank you to the audience. I do note that there are many questions, and if you feel that your question hasn't been covered, Iris, I'm sure we can find a way to transmit people's questions to the relevant person. So, you know, please do, if you want to put something in, we'll get it answered for you. This webinar has been recorded, I think, Iris, and will be available in a couple of weeks. Is that correct?
Yes, I think it will be available on YouTube after a couple of weeks. I mean, we just need to edit it and have all the speakers approve. Thank you. Well, a big thanks for listening. Very much hope to see you at a future webinar, and have a very nice evening. Bye-bye.